sink in and you're really going to take it seriously. If you get another OWI, that is a lifetime revocation, or could be a lifetime revocation depending on when your convictions were and what the Department of Motor Vehicles does. And to not have your driver's license in this county is very difficult, especially if you have kids and you're married and all of those things and all that a family needs to do. The next time you're in a vehicle, make sure you're not under the influence of anything. And I do have to tell you that THC is illegal in Wisconsin. I don't know if it'll ever be legal. It's only legal in the states surrounding Wisconsin. So if you want to partake in it, I strongly suggest you only do it in those states. But make sure that you're still not under the influence when you come here, because it stays in your system for a very long time. We will go on the record in the matter 26 CF35, State of Wisconsin versus Leon Chapman. The state appears through Assistant District Attorney Jose Vila in person. Mr. Leon Chapman appears in person with his counsel Daniel Chapman. We're set today in this matter for a status conference. Mr. Daniel Chapman, can you please update the court?
Your Honor, I'm trying to verify a conviction from about 30 years ago, I believe, in North Dakota, 20 years ago. And they tell me there's a transcript available, but they haven't produced it for me yet.
From 20 years ago?
I forget the date, but 1 second. I think it was 2005.
Mr. Vila?
Are you referring to the North Dakota 2011 case?
Yes, 2011, so 15 years. They tell me that there's a transcript. I made a written request. I've been told by the clerk there that it's been referred to a court reporter to transcribe for me, and I have not heard anything back. I did follow up, and they said they would follow up with the court reporter.
Okay, so you just need a little bit more time.
Yes, please.
All right, that's not a problem. Leon Chapman, you're behind on your payments for your attorney, so you're gonna need to stop and see the clerk before you leave?
Yep, I was gonna mention that or whatever, towards the end of the month or whatever, I'll be able to get caught up on that a little bit.
Okay, I'll give you till the end of the month to do
so-
that. I'll take you for your word, okay?
And then, yeah, because right now or whatever, I currently don't have a job right now, so
And it looks like you're going to be able to get a job soon?
I'm hoping.
September 28th at 10:30. You're coming back, Mr. Chapman, September
Yes.
28th at 10:30.
Thank you.
Thank you. We'll see you then.
She'll give you a notice. You're
Come
good to
get your
go.
notice and you're free to go. Make sure you stop at the clerk's office and talk to Amy, talk to Danielle, and then just update her and let her know that you talked to the judge, and by the end of the month, you'll be caught up. Okay?
The payments I've made so far.
Oh, good. Okay, well, yep, don't use those. Yeah, so just update her, because they're the ones that monitor it like every day. And then, so then I won't have to have them hound you, okay?
Got a couple applications up there.
Well, good luck.
Got single parent. And that's that hard to work night shift.
How old's your child?
5, well, just turned 6, but
That is hard.
so
Hear ya.
pretty much until school starts or whatever, a little bit, and I can get them in there, so.
Well, good luck with that too.
Thank you.
I understand completely. We will go on the record in the matter 25 CM 155, 25 TR 455, State of Wisconsin versus Thomas Towell. The state appears through Assistant District Attorney Jose Vila in person. Mr. Towell appears in person with his counsel, Daniel Chapman. We're set today in this matter for a plea and sentencing. Mr. Chapman, can you please update the court?
We are prepared to move forward with the plea today, Judge.
And has he sat 48 consecutive hours?
He has not.
So, Mr. Towell, do you understand that you would report to jail immediately here today?
Yes, ma'am.
Okay. He's going to plead to the OWI third as well as the possession of THC misdemeanor. Is that correct?
Correct, Your Honor.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document, Mr. Towell?
Yes.
Did
Your
your
Honor,
attorney?
It's toll.
Oh, it's toll. I'm sorry.
Okay.
Oh, I should have known that because there's a Russell toll. I don't know if you're
I'm not related.
not related. Yeah, from back in the day. I apologize.
That's okay.
So, Mr. Toll, did your attorney go over with you the plea questionnaire waiver of rights form?
Yes, Your Honor.
Did he essentially go over it word for word?
Yes, Your Honor.
And you understand them completely?
Yes, ma'am.
And did you sign that document?
I did.
And so on this document, it states that you are pleading guilty to the OWI third as well as to the possession of THC misdemeanor. Is that correct?
That is.
You're 48 years old. You have 12 plus years of schooling. You can read, write, and you understand the English language. Is that correct?
Yes.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum and minimum possible penalties that you face?
Yes, Your Honor.
You're not receiving treatment for mental illness or disorder and no drugs, alcohol, or medications.
Correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Did your attorney thoroughly go over those rights with you?
Yes,
Do you understand them completely?
I do.
Do you need me to go over these rights with you in any more detail?
No, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove as to possession of THC count 3 that on or around June 9th, 2025 in Burnett County, Wisconsin, you knowingly possessed a substance, THC? Do you understand what the state would have to prove?
Yes, Your Honor.
You understand the maximum possible penalty could be a fine of up to $1,000 or 6 months of incarceration or both?
I do.
Do you understand as it relates to operating while intoxicated or under the influence, while operating a motor vehicle while under the influence, third offense, the state would have to prove that same date, that same time, that same place that you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand that the maximum, or there's minimums and maximum possible penalties, and that upon conviction for this misdemeanor, you shall be fined not less than $600, but no more than $2,000, and imprisoned for not less than 45 days, but no more than 1 year in the county jail?
Yes, Your Honor.
Do you understand that there is an agreement that's been reached with the state, but that I'm not bound to follow that agreement? You understand that?
Yes, Your Honor.
That means I could sentence you to the maximum possible penalty for both of these crimes if I thought it was warranted. Do you understand that?
I do.
Do you wish to proceed and enter guilty pleas?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? And in particular, there's a section called the probable cause section where it basically says what happened and why you were charged with the crimes.
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Mr. Toll, are you pleading guilty to an operating while under the influence third offense because you are guilty?
Correct.
Are you pleading guilty to possession of THC because you are guilty?
Correct.
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Correct.
and voluntarily?
Yes, ma'am.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes,
Are you satisfied with his services?
I am.
Do you have any questions for the court or for your attorney before I proceed?
I do not.
As to count 3, possession of THC, a misdemeanor, how do you wish to plead?
Guilty.
As to count 5, operating while under the influence, third offense, a misdemeanor, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of those 2 offenses. The other matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and is there a PAC? The court will also dismiss and merge in count 6 with count 5. Argument and sentencing recommendation, Mr. Vila.
Thank you, Your Honor. Mr. Toll is here taking responsibility for his actions. He has since completed the IDIP program and hopefully has learned some valuable programs and resources so that he does not reappear in front of the court in this manner. This is an OWI third with the THC component. As such, if he does choose to operate a motor vehicle under the influence again, his next one's a felony. I think there's sufficient deterrence there for him to try and keep that off his record. As it relates to the THC, the agreement here, I believe, is for probation. I think any need to protect the public will be accomplished by that point, as well as the necessary license revocation provisions for the OWI. As such, I would ask the court to adopt. Thank you.
All right, Mr. Chapman.
Your Honor, I want to explain the firearm briefly. Mr. Toll informed me that that gun was not his. He didn't put it in the car and he had no idea it was in the glove. I think it was the glove box at the time, but the officers found it. I know it's not exactly probative beyond a reasonable doubt, but he did tell me who the person that owned the gun was, and I was able to find a police report of that same person being arrested with that same gun recently. So it was plausible. With respect to the OWI, his priors were from 1998 and 2014, so he had 2 prior first offenses, and this will be the first time he's had a criminal OWI. He did his assessment. He's fully employed, he's married, he has 2 children and has no other record. I also believe this is an appropriate resolution and would ask you to follow the agreement.
All right, thank you. Mr. Toll, is there anything that you want me to know? Anything you want to say here today?
Oh, Your Honor.
All right. Well, Mr. Toll, Mr. Vila said it in his argument to the court, and I'm really hoping that you're going to let this sink in and you're really going to take it seriously. If you get another OWI, that is a lifetime revocation, or could be a lifetime revocation depending on when your convictions were and what the Department of Motor Vehicles does. And to not have your driver's license in this county is very difficult, especially if you have kids and you're married and all of those things and all that a family needs to do. Operating while under the influence is a serious offense. It's the 3rd offense or conviction for you, so it makes it a little bit more serious. But you are taking it serious and you're pleading guilty and you want to make the changes and you want to do the things to not be in this position again. Hopefully you have learned and it's not going to happen, because I really don't want to see you here for an OWI-4.
Me neither.
The fact that the weapon makes complete sense now, and I trust Mr. Chapman when he looks into things and the evidence that he does find. So with regards to that count, I do understand it better now, so I appreciate that. The next time you're in a vehicle, make sure you're not under the influence of anything. And I do have to tell you that THC is illegal in Wisconsin. I don't know if it'll ever be legal. It's only legal in the states surrounding Wisconsin. So if you want to partake in it, I strongly suggest you only do it in those states, but make sure that you're still not under the influence when you come here, because it stays in your system for a very long time. I do think that the agreement is appropriate. I do have to look at the seriousness, and I have to look at you and your history and needing to protect the public. The public will be protected, at least for a period of time. You're going to be punished. You're going to have a sanction. You're going to go to jail. So what the court is going to do is I am going to this was a restricted control, I believe, $1,286 in fines and fees plus a $10 blood draw fee, 45 days of jail, $24 months revocation of your driver's license, and 25 or 24 months of an ignition interlock device. Are you currently working?
Yes, Your Honor.
All right. With regards to and that's just, I'm doing that as a conditional jail right there, the 45 days, because I'm being asked to place you on probation for the THC. I'm actually placing you on probation for the OWI 30. As well as the possession of THC charge. The THC charge is not going to have any conditional jail attached. I'll place you on 1 year of probation. I'm not going to order the community service, because what I'm going to do is I'm going to order that you apply to the Burnett County Treatment Court. And if you qualify, if you're accepted, then you engage in that program. Because quite honestly, I don't want to see you get an OWI 4th. And I don't want to see, because that harms you, it harms your family, and it harms Burnett County. So that's why I am ordering as part of this that you apply to the treatment court. So 1 year of probation. And you haven't sat 48 consecutive hours, so this is an immediate report. You have to report immediately, okay?
Okay.
And I don't know if you asked or monitor, because you did you complete fully the IDIP?
I did.
He has, it's set up for EHM set up on Friday.
Okay, on Friday. So then you can talk to Mr. Hatch when he sets you up about the treatment court and go over that. I will give you the ability to serve your time on monitor. Follow the rules and the procedures. Stay away from gasoline. Stay away from rubbing alcohol when you have the monitor near you, because it will set it off. And that will mean that it is positive, and you'll be told that you're immediately revoked off the monitor. You must go serve your time with no good time and no Huber. But this is conditional jail, but you'll be out on monitor. Hopefully you're going to do well. I just really want you to do well, Mr. Toll.
I do too.
And I'm going to tell you that if you're accepted and if you do participate in our treatment court, you are going to be one of our first OWI people in 8 years, because we have totally revamped our treatment court for OWIs to include them, because to me and to my team and to our county, those are serious, and we need to address that. So I would be excited to have you in our team, or on our program. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I have to order your DNA. And when you go to the jail, they'll make sure that you take that. With this, I believe you could request it be expunged through a written letter to the Department of Justice, not to the court, to the Department of Justice. You can Google it and you'll see it's very easy to do. You're not working right now?
I am working
You are? Where are you working?
at Ingstrom's.
Oh, okay. That's really good. Okay, at Ingstrom's.
Yeah, your cousin's my foreman.
Yeah, okay. So you work a lot.
I do. I'm missing work right now.
You work a lot yearly,
I'm a lead foreman as well.
and that'll interfere with your ability. Treatment court will interfere with your ability to be able to provide for your family. Because you work a lot. I know you guys do at Ingstrom's.
Yeah, we're pretty busy right now.
You know what I'm gonna do? I'm gonna remove that condition, unless you want to do treatment court, but it's a lot of work.
I would rather just go to work and make the money I need to make.
I want to make sure that you can support your family.
Thank
So
you.
what I'm gonna do instead, because I'm changing my whole way of thinking right now. I'm gonna leave you on probation. What I'm gonna do instead is I want you to complete the program with Dave, the skills directed practice program. Okay, I know that you've done other things and, but treatment court takes a lot of time, and I want to make sure that you really have the grasp that, and you're not going to do this again. So that's what I'll do. And so you can talk to Dave about that
Okay.
on Friday.
Great.
And so payments, are you able to pay that off in full, or would you need a payment plan?
A payment plan would probably be best at the moment. I was off of work for 5 weeks because I had my finger amputated.
Ooh, what happened?
A table saw accident.
At work?
Yeah,
Oh, man. All right, and for the,
In case you need to remember it.
for the THC charge, I'm only gonna assess the $200 DNA surcharge since there's a high fee with the other matter. I'm gonna say payment of $250 a month until paid in full. You can have it taken directly out of your check. If you want to pay more than that, great, because then you get me off your back, because not only will I enter a civil judgment against you if you don't pay it, but I will issue a warrant and you could sit up to 6 months in jail. And I do track that, and I'm a stickler at people making their payments because that's part of the sentence. You're going to make the payments here to the clerk, not to Department of Corrections.
correct.
Okay?
Yep.
This program and class, I'm going to say that it needs to be completed by the end of January. So that gives you some time to be able to do that. Mr. Vila, am I missing anything?
Did the court already provide the right to appeal?
Yep, 20 days to appeal. Oh yeah, I'll get to conditions. I do have conditions, I guess, while you're on probation. Conditions of probation: absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. Testing, regular testing to ensure that. Absolute sobriety means no alcohol, no illegal substances. That's about it. Make sure that you get your driver's license. But you've done most of the things, all the things that you need to do. So
Yeah, I
you're
have
doing
one
that.
more class I signed up for and paid for in September coming up.
Okay. Mr. Chapman, what else am I missing?
He has 2 days of sentence credit.
Okay, 2 days of sentence credit, but you have to sit that 48 hours, and once you're done with that, you're gonna be good to go.
Okay.
Okay?
Yes.
All right, thank you. Then we are adjourned.
One more document I need to go through with you.
Okay. Great. Okay. Awesome, thank you.
Last thing I need is, do you know what it means to appeal? Appealing means if there was anything in this process that you wanted to back up and change, you
Oh.
have the right to ask a higher court,
Yeah.
Court of
Okay.
Appeals or the Supreme Court to
I was gonna
undo
do a
something,
post, but
back it up
stayed,
and
but-
start over.
I'm not gonna do that.
Okay, I'm gonna check that you don't plan to appeal, but like it says right there, you have 20 days. So if you have questions or if you change your mind, you gotta let me know within 20 days.
Correct.
If you could just sign and date there, it says you understand you have the right to appeal. I'll fill out the rest.
Okay.
Take that. Probation will probably want to see it if they don't print out their own copy,
Okay.
and you are good to go.
Thank you very much.
Good luck.
Ms. Bolio?
Are you gonna take him down or should I just tell him to report John to the jail?
You can just report.
Okay, I'll go tell him just to make sure, but I kind of thought somebody would be walking around.
That's typically how you've always done those. They just report themselves.
Yeah, but if you want to take them, you can take them, or, yeah, I trust them, because if they don't, it's a fleeing charge, so.
Yeah, I would assume that too, but I didn't actually tell him to go right down to the jail, so nobody actually did. I just wanted to make sure that he knew that, that was not negotiable.
Thank you, Mr. Chapman. We will go on the record in the matter 25 CT 56, 26 CM 37, State of Wisconsin versus Marie Bolio. The state appears through Assistant District Attorney Jose Vila in person. We have Ms. Bolio in person with her counsel, Daniel Chapman. Mr. Chapman, this could have been a potential plea. Can you please update the court?
Your Honor, Ms. Bolio has not yet completed the prerequisites. She has to do the anger management program with Mr. Hatch and get her driver's license back, although that is less important. She needs more time to do those things, and she would ask for 2 more months, please.
October 30th, 9:15.
That works for me.
All right, October 30th at 9:15. Make sure you have the anger management completed by then.
Yeah, I
Hopefully you
will.
have your driver's license and we'll be all good to go.
Yeah, I
All right,
will
you
for
can come get
sure.
your notice and you're free to leave.
All right, thank you.
Thank
Due
you.
diligence on that, okay?
Yes. I will.
Stacy, we're off for, I guess we have a chunk of time.
Dan, do you have
So
any-
I'm gonna
Oh,
log
what's your-
off and we'll see you later.
Yeah, I do.
No worries, I can hear you.
I do not yet have, Washburn, or I probably did, and they're probably gone, actually, so. I don't know if we're actually gonna have the Washburn case or not.
The CV case, is that off?
Yeah, that's just by affidavit, so we just have to, I don't think anyone is here. Is anyone here for Paul Cordy? Nope. Nobody. I'll just have to message Mary but she was on her own scheduling call. So they probably called and said, what's going on? Never mind, they just popped up. Washburn, can you hear me?
Yes, Your Honor.
We can.
I apologize for the delay. I've had to deal with an unexpected issue this morning and still not under control, but I will make sure that it is shortly. So I apologize for the delay. I cannot see anybody.
It's not necessary, Your Honor. This is Attorney McLaughlin. I don't need to go in the record. My client has appointments to get her driver's safety plan, but needs some time to complete which is necessary to get her license. So, absent the court's objection, I think opposing counsel does not object to an adjournment for her to accomplish that.
Okay, and when does she think that she's going to be able to have that scheduled and get it completed?
You're promising 60 days. Is that correct, Ms. Storin?
As long, yeah.
Ask a maximum of 60 days. If the court wishes less, I understand. If we don't have it solved by then, we'll plead out one or the other.
I can do October 1st.
I don't work Thursdays, Judge.
Oh, that's right, you do not. I can do September 28th at 1:15.
I can do September 28th at 1:15 as well, Judge.
In the
Mr.
court, in Washburn County.
Monday is our normal intake days, and I have a sentencing hearing in front of Yackle at 1:30. So as long as Christian
At
can
1.
cover bonds and we can be
I
done by
can move it.
1:30.
Does October 5th at 1:45, would that work better?
That works fine for,
My son has his 1-year wellness visit that day. I'm
my client has a child medical thing that day. I apologize, Judge.
And, okay, Mr. Marco, your mornings are pretty busy on Mondays, correct?
Yes,
Okay.
we do split our status conferences in the afternoon. I have the 2 o'clock hour. Christian has the 3 o'clock hour. So if we did something around 3 or 3:05, I should be done with my 2 o'clocks by then on any particular Monday.
Okay, that's usually when I do I have my prelim block there, but I could do it quickly before. So we could do October 5th. Can we just say 3? And if you're running a little late, you're running a little late.
Can you be at 3? One moment.
Oh, that's right, her wellness check.
I
She's,
don't remember the
Uh,
time. Hold on. Give me 1 second. I'm so sorry.
she's.
Or I'm
I'm a-
completely open. I had something come off on October 7.
7 is fine with me, Judge. I prefer the morning. I don't work afternoons. Anytime on the 7th in the morning, Judge.
Would the 9th
Oh.
work for Washburn? Or 9 o'clock work for Washburn?
Jim, we have Tea Garden set.
Oh,
for
yeah, I'm
jury
sorry.
trial that
We're,
day.
I'm blanking. We have a jury trial that day.
Okay.
How about the following week, Your Honor? Where are you on the 5th?
It's 1:15, but it's in Rice Lake.
All right.
so-
Well, the 5th is not good, Judge. I guess I apologize for my client has a child medical appointment. Some other day that month, perhaps, or earlier.
Doesn't really work. Doesn't really work.
Um,
Well, here's the deal. I can go out as far as October 20th in the morning, but then I'm
That's-
gonna be really frustrated if she hasn't done what she needs to do.
so I'll
I-
take the 20th and she,
I've got a jury trial on the 20th.
How about the 21st?
in the morning.
21st, I am available.
So am I in
9
the morning.
AM,
All right. Yes, Judge.
9 AM, October 21st, and I am telling you very clearly right now, Ms. Storant, that you must have your things completed by that day. I don't want to hear something came up and I do not have money and I could not go through with my assessment, okay?
Yes.
Here's the promise,
you.
Judge. She either has her license on the 21st, which case I believe the state will be moving to dismiss, or she'll plead to the charge, one or the other. That's,
All right,
that's,
okay.
that's defense
on.
counsel's promise to you.
Was it October 21st?
Yes.
We don't have a courtroom available at that
Oh,
time.
we don't have court.
We have
Oh, of
family
course.
court that day.
Oh, wonderful. All right.
Oh, yeah. October 20, no, because it's, well, October 26th on a Monday, I can do afternoon.
I can do that. Can you,
I could do 3 o'clock,
I could
3:05.
do- Again, that's my, prelim block, but I could put you on that date and time if we have court.
3 p.m.?
Yeah, does that work for court?
It does, yes.
All right.
Okay, October 26th, we will schedule you for 3 o'clock. Again, if you're a little late, Mr. Marco, that's whatever, it's fine. And then we'll set it for a plea and sentencing. And it may be off if she's done all that she needs to do, so it can be done by paper.
Yes, if we can get this by stipulation, Judge, we'll submit it early.
That sounds good. Anything else?
No,
This time.
no, Your Honor.
Okay, thank you.
You have my business card?
Yes.
Let me
I
give
do.
you another one.
Okay.
Let's get this, in the words of Larry, the cable guy, let's get her done, okay?
Okay. Thank
Well,
you.
and like, just explain to her what meant by paper. If she gets her license back, you get me a copy, we'll file some paperwork, and then we don't have.
Yeah, we don't have to have court if you can get it done, okay?
Okay. Yes.
Thanks, Aaron. All right. All
Thank
done.
Thank you.
Get her done.
Yes.
All right, take care.
Okay, thank you. I just need 2 minutes to quick read something. We will go on the record in the matters 26 CF 9-4, 25 CT 28, 26 CT 3-4. State of Wisconsin versus Zachary Howard. The state appears through Assistant District Attorney Jose Vila in person. We have Amber Sherwood defends in person with Mr. Howard. We're set today for status conference on one of his CTs and initial appearances on the other matters. Ms. Sherwood, you are only counsel in the CT matters. Were you aware of the felony case?
I was not, Your Honor.
I will print you, never mind, there's a copy of the criminal complaint is now being served upon counsel and Mr. Howard. What I can do is I can just give you time to go out and talk about it because it's serious. And he needs to understand the charges and the maximum penalties. And then we will come back and I will we'll go through and have his initial appearances, okay?
Yes, thank you, Your Honor.
All right, thank you. Momentarily adjourned. Ms. Mose? What are you chewing, Miss Mose?
Ice.
That hurts your teeth. It could chip your teeth. We'll go on the record in the matter 25 CT 45, State of Wisconsin versus Vanessa Mose. The state appears through Assistant District Attorney Jose Vila in person. Miss Mose appears in person, but you missed the last court date, I think.
No.
You did
I
not,
was
or
here.
it was the one before that.
Yeah.
Okay,
April.
and so you needed to take your permit test and that's all you needed to do, I think?
So I did that. I got my test. I just need to
Passed
get.
it?
Yep, I
Good
just need to get the dollar amount for the driver's license and then the vehicle that,
Free ignition interlock?
Mhm.
So how?
no,
long-
not ignition,
Oh, you
interlock,
don't
but
need that?
you know, that qualifies, you can't have like dash lights on and everything has to work.
Oh, to drive.
Yeah.
Yes.
For
to
the
do-
test.
So when do you think you realistically can do that?
So we were just actually talking about that on the way up. We're trying, one of the other workers is gonna see if I could use one of the work vehicles for the truck.
Tribal vehicle?
Yeah.
That would be
So-
very nice.
Mm-hmm.
And so you would be able to use that. And then, I don't think it's a lot of money to get your license, but
Mhm.
I don't remember the amount, if it's $70.
Yeah, see, like, I'm not sure about the amount either.
So how long do you think it's gonna take you to be able to have that money to?
I give it a month.
Okay. I can schedule you for September 28th at 1:15, okay?
Okay.
September 28th, 1:15. That means that you should definitely have all of that stuff done by then. If you do have it done by then, we will not need to come back because the state will dismiss it as long as you give them proof of your
Yep.
driver's license.
Mhm.
So once you get your driver's license, just walk it down or mail or fax it or whatever they accept,
Mhm.
and give them a copy of your driver's license, and then you will not need to come back, okay?
Okay, yep.
All right, so you can come up here and get your notice and you're free to go, and any money that you've paid would be reimbursed. to
Okay.
you, Okay? Mr. Stanhope? Stacy, Daniel Bruce is off. He's been moved to another day down the road.
Okay.
Mr. Stanhope, I do not have. Who are you? You individuals? It's good to see you, Dr. Otto. Who are you?
Robert Duran.
Who?
Robert Duran.
Okay, you're 9:30, and who are you?
David Johnson.
That's right. Okay, so you guys are early. Would we be in victims' rights compliance to be able to go early or no? Well, it's 2 minutes, but
2 minutes,
it should be fine.
Yeah.
Your hair's cute. Okay, let's go with Mr. Durand. We will go on the record in the matter 26 CM 62, State of Wisconsin versus Trevor Durand. The state appears through Assistant District Attorney Jose Vila in person. Mr. Durand appears in person without counsel. We're set for a status conference. I believe at the last hearing, you were not able to issue or to tell him an offer, but was he able to go down and talk to your office?
An offer was made, Your Honor, according to my notes, back on May 27th, it was for him to get the AODA and anger management, and we would do this as an ordinance.
Were you able to do that?
Monday was my last day.
What?
Yeah, Monday was my last day. And
Okay,
Dave said it takes a little while to get the proof through here.
okay, so we're waiting for Mr. Hatch,
Huh?
Dave Hatch.
Yeah.
Okay, and so, yeah, I don't yet have confirmation. Usually he sends it. And if it was Monday, he could be a little behind. So what we could do is reset this, and at that time, quite honestly, if you know that there's proof, you do not need to appear, because what would happen is the state would go, Judge, I'd like to amend this to an ordinance, and I can say, I find you in default, you're not here, so I'm just gonna assess the money, and then you have bail paid, and that can go, and that can pay for that, and then you wouldn't necessarily need to come back.
I'll call, make sure.
Yes, you can call to
Okay.
make sure, but if you just wanna come, that's totally cool too. Okay, so I can give you a few, well, a few weeks or something, just to make sure that that all can happen. August 24th at August 24th at 11:15. Wait, that's a Schmidt week. August 31st at 1:45. Okay, August 31st at 1:45. That should be plenty of time for Mr. Hatch to send his proof. And for you, you can call the clerk's office
Yeah.
or the DA's office to see if the proof has been provided. And then it's your choice again, of whether or not you want to come into court or you don't, because you cannot get a warrant for failing to come to an ordinance. Okay.
Okay. Yep.
Okay, so you can come get your notice and you're free to go. Mr. Johnson? Down and slide back. We will go on the record in the matter 26 CM 36, State of Wisconsin versus Jaden Johnson. The state appears through Assistant District Attorney Jose Vila in person. Mr. Johnson appears in person without counsel. We're set today in this matter for a status conference. We are in victims' rights compliance,
Yes, Your Honor.
and offer has been presented.
Yes, Your Honor, the offer for this one was presented back on April 22nd, according to my notes. And that one was to do the anger management class with Mr. Dave Hatch, and we would do a DC for cost only.
Have you done that program yet?
No, Your Honor.
Or are you accepting the offer?
Yes, I'll accept it.
Okay, and so do you understand that it takes, I think, 4 weeks or something to do? When are you going to be able to set that up with Mr. Hatch?
I know previously, I did feel bad for not getting it done by now. I could probably do it from here on out for sure. I do have his number right now.
All right, what I'm going to do is I am going to set this on the Schmidt week because I'm not going to go way too far out. It's just gonna be a status for me to be able to check that he's actually doing it and we're moving forward. August 24th at 11:15. August 24th at 11:15, you're gonna come back to court and you're gonna say, yeah, Judge, I'm doing it. I'm almost done. I have this and I need this much more time, okay? And if you are accepting the offer, then that would mean that it looks like you have money posted. You should be good. So, the same thing that I said to the last gentleman, if you're done by then and there's proof, then you wouldn't need to come. But I don't think that it's possible that you can be done by then. I'm setting it so close, so quickly, just to make sure that you're enrolled and you're doing that, okay?
Okay,
So come up here and get your notice and you are free to leave.
okay, thank you very much.
Mr. Howard.
Did you?
We will go back on the record. Same appearances as previously noted, 26 CM, excuse me, sorry, 25 CT 28, 26 CF 94, 26 CT 34, State of Wisconsin versus Zachary Howard. The state, same appearances. Ms. Sherwood, you were able to go over the new charges in the felony complaint as well as you went over the CT charges with Mr. Howard?
Yes, Your Honor, I've gone over the criminal complaint for all three charges. We waived the formal readings. For both CT matters, we would plead not guilty. We plead not guilty for the misdemeanor matters in 26 CF 94. We ask for preliminary hearing and waive time limits.
Thank you so much. I can set a preliminary hearing on August. Wrong week.
This is
Mr.
technically,
Schmidt, wait.
yeah. The Mr. Schmidt case, Your Honor.
It's hard when I'm visiting judges using my courtroom and time blocked off and I can't use it. Nice when we had two, maybe. Courtrooms. I could do 2 o'clock on August 13.
That works for the defense?
All right, 2 o'clock, August 13. Not guilty pleas to all of the misdemeanors still on Ojibwe Drive.
Yep.
Telephone ends in 8479.
No.
What's your telephone number?
754163219.
We have that in one of our files, so thank you. Can we remove the other number?
Yes, and my minute's actually about to go out, so I'll update the court with a different number as soon as this goes out.
Why can't you keep the same number?
In the middle of jobs right now. I've been more of a stay-at-home father, so I'm about to pick up a part-time job.
I know, I don't understand.
Continue
though.
my schooling.
If you get more minutes for a phone, why do you have to get a new telephone number? Can't you just upload more minutes or pay for more minutes?
That's exactly what I'm trying to do, and if I can't, I'll have to update the court with a different number. It's through an app on my phone that would be for free for me until I get the funds to get my number back working.
Okay, I don't understand that, but okay. It's usually before when you had the track phones and then you buy little cards to get more minutes and you add the minutes to your little track phone, then you can keep the same number. It just adds the minutes to the phone.
I'm on a Verizon plan and I'm a little bit behind, so it's getting close for it to cut off before I pay for it.
Okay, all right.
Just to update the court, we do hope to have someone assigned to this criminal or this felony matter. Our office is waiting for date of birth for one of the victims so that we can finish our conflict check.
Okay, and so you're not quite
The
certain
13th
that
at
you
2
would
o'clock.
be able to take that felony case?
As soon as we get the date of birth for one of the victims, we can conflict it. If it's not a conflict for my office, it will be my case.
Okay, sounds great. Thank you so much. We'll see you then.
Thank you.
Thank you. We're adjourned.
Thank you, Judge.
Thank you. Mr. Stanhope, can you hear me?
Yes, I can.
You too. We will go on the record in the matters 26 CT 08, 26 CT 13, State of Wisconsin versus Corey Stanhope. The state appears through Assistant District Attorney Jose Vila in person. Mr. Stanhope appears by telephone conference without counsel. Mr. Stanhope, why were you unable to come here to court in person today?
Because the work I laid concrete and there's only two of us, and so I really couldn't afford to not be on the job site.
And you know, I understand that, Mr. Stanhope, but you gotta call a lot sooner than, 10 minutes after your hearing. It has to be at least last week where you say, you know what, Judge, is it possible for me to appear by telephone? That would make my life a whole lot easier because I'm here for operating while revoked and I don't have the ability to drive.
I believe on the paper that I got, it said I was approved to call.
Well, I'm not seeing that.
All right, well, it won't happen again.
I'm looking at the notice of hearing right now and it does not say that you have that ability. All right, so just more notice than 10 minutes after your hearing, okay?
I understand.
All right, so where are you in the process of getting your license? You needed to do an assessment and you were, I think, saving the money?
Yep, I was saving the money. I also had to pay Minnesota $640 because I had to pay over there to reinstate so I can do Wisconsin. So I just paid that. I'm just gotta pay Wisconsin and then the assessment.
So how much do you owe Wisconsin now?
Like $400, I believe, plus $300 for a reinstatement, and then the assessment is probably gonna be like $400.
So I need a realistic time when you think you can get all of that done because I don't want to keep dragging this out.
I want to say like a month and a half. I should be able to have everything paid and the class done.
Okay. October 1st at 2. October 1st at 2. Hopefully you'll have all that done by then, okay? If not,
Okay.
and if you need to appear by telephone, please call, at least a couple days ahead of time, all right?
Okay.
And let's say that you do everything, you get your assessment and you complete everything by that date and time. You should not need to come to court at all if you're able to give a copy of your driver's license to the district attorney, okay?
Okay.
All right, we will see you then.
Thank you.
Thank you. Okay. Mr. Peterson. Yeah, I know, it's like 3 minutes, but usually he's here early.
Did you see the?
Okay. Stacy, we're just gonna take a quick little break so you can have a little break and then if and when Mr.
right.
Something about Miss Simmons. Mr. Harrington?
Yes, Miss Simmons was going to appear by telephone. It says Andrea's phone there, but that doesn't look like an Andrea to me.
Doesn't to me either, and I don't know.
There she is. I think that's an Andrea.
Okay, there we go. Can you hear me, Andrea?
Yeah, I can.
We will go on the record in the matter. 26 CM 87, State of Wisconsin versus Andrea Simmons. The state appears through Assistant District Attorney Jose Vila in person. Ms. Simmons appears by video conferencing with approval of the court. Eugene Harrington, Defense Counsel, appears in person. We're set for a status conference. Mr. Harrington, can you please update the court?
Judge, I filed a request for discovery early this morning. I talked to the DA's office about 20 minutes ago. They're going to have the discovery for me. Mr. Vila and I have had a discussion. Mr. Vila actually sent a proposal to me by email the day after I was appointed by the Public Defender's Office. I've had one conversation with Andrea about the proposal, but I haven't heard her version of the facts yet, and I really need to do that. I expect that we'll get these matters resolved relatively quickly. I request that it be set back for a return date, 45 to 60 days.
All right, what is the offer that's been presented?
Plead to count one in the traffic matter, operating while impaired, first offense, and then deferred acceptance of a judgment as to one of the two battery counts, dismiss the other, 1 year contract. For the OWI, be the standard disposition for OWI 1.
I'm missing an OWI. Yes.
That one, yeah, that one should be filed either today or tomorrow morning. We just put the finishing touches on it. I sent it preemptively to Attorney Harrington, so it was on his radar.
Okay, makes sense, because I'm like, I don't have an OWI here.
Neither do I yet, Judge, but you know,
That's the offer.
we'd like to be reasonably efficient sometimes.
Okay. Sounds good. Okay, let's get a date out. I can do October 1st, either in the morning or the afternoon.
Afternoon, if I could.
2:15?
2:15 works. Andrea, does that work for you? October 1st? 2:15, preferably come up here.
Okay.
All right.
All right. Thank you.
October 1st at 2:15. All right, we'll see you then.
All right. Thank you.
The status is fine.
How much time do you have that day?
Well, the rest of the afternoon's open. Potential plea?
Yes,
Okay.
potential plea.
Yeah, okay.
You have the record?
Yeah. Well,
Thank you for helping me out with my stupid.
this matter for status conferences. Mr. White, please update the court.
Thanks, Your Honor. This is a case that we're working towards the IDIP resolution. Mr. Notnoki has been in contact with Tess Anderson, was directed to communicate with Dave Hatch. Sounds like they have a plan for a meeting on August 12th. So looks like we're about a week away from them beginning the program. I'm not sure where that puts us in terms of just scheduling a status a couple weeks out, or if we should just put it on for a plea hearing about 2 months out. I'd be okay with either one.
Mr. Notnoki, I think we talked about this at the last hearing, that you were supposed to have signed up and gotten everything ready to go by this hearing.
Yeah.
What was the holdup?
Just I tried getting in contact with them beforehand, but they kept just redirecting me to like back and forth to Tessa, to pretty much like the same people that was mentioned before, and they just kind of said the same thing, just like, yeah, you just got to get everything set up before you can, you know. So I just said, let's just hurry up and get me enrolled so I can just get through this.
Start?
Yeah, so I can start. Exactly.
Mr. White, I would like to have a status. And you can appear by Zoom. I just need to know if he's actually doing the program because I'm not gonna keep waiting and prolonging the case. Can you do August 31st at 2 o'clock? And we can set a tentative plea too, because here's what I'm gonna do. We can schedule that, and Mr. White, if Mr. Noki informs you that he's already enrolled and he's doing the IDIP, that can come off. I just want to make sure that this is progressing.
Yeah, that time will work, Your Honor, and we'll try to keep in touch about his progress.
And so if you want to set a tentative plea hearing, we could do that. October 15th at 1:30.
Your Honor, I should have time that day if something's scheduled now, but I think that'll come off. So 15th at 1:30 works.
Okay, October 15th at 1:30. Mr. Noki, you can come and get your notice. Thank you.
Do you still want the review on the August 31st?
If he gives you confirmation that he's in IDIP,
Okay,
then it can be removed.
okay.
That's only set because I want to make sure that he's enrolled and doing what he needs to do. I don't see Mr. Lightfeather. Would you like to try and call him?
Your Honor, I haven't been able to reach him. Just call him once he's.
Do you have any other clients? Doesn't look like it.
No.
Other than Lightfeather.
No one for.
All right,
hearing.
we will go on the record in the matter 25 CT 33, 25 TR 492 and 493. State of Wisconsin versus James Lightfeather. The state appears through Assistant District Attorney Jose Vila in person. Mr. Lightfeather fails to appear. These matters were set for statuses. We have Nicholas White, his counsel, making an appearance here today. Driving is good. It was set for 2:45. It is 3:03 and no appearance by Mr. Lightfeather. He doesn't appear by video conferencing nor in person. The court is looking at all of the video cameras, entrances and exits, and I do not see Mr. Lightfeather. What is the state requesting?
I would ask for a warrant, Your Honor.
Court will issue a warrant, $1,000 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. As to 25 TR 492, failing to keep vehicle under control, the court is going to default him and assess $213.10, 4 points off of his license. As to 25 TR 493, failing to stop, the court's going to default him and issue an amount of $175.30, 3 points off of his license. Mr. White, if there isn't a reasonable excuse, a very good, reasonable excuse as to why he's not here, I may reconsider, especially perhaps reopening the 2 tickets.
Okay.
So if you hear from him, please notify the court.
Understood. I'll do that. You might see him before I do. So
All right, thank you. We are adjourned.
thank you.
And thank you, Mr. White. Mr. Rapley. We will go on the record in the matter 26 CM 88, State of Wisconsin versus Derek Rapley. The state appears through Assistant District Attorney Jose Vila in person. Joe Feliski, Defense Counsel, appears in person. Mr. Rapley appears by video conferencing with approval of the court. We're set here today in this matter for a status conference. Mr. Feliski, can you please update the court?
Thank you, Your Honor. The state has made an offer to resolve on this file, proposing that Mr. Rapley plead to either count 1 or count 2 of the complaint. The parties would be making a joint recommendation for court costs, a time served sentence, dismissing and reading in the other count. I've relayed this offer to Mr. Raffley and discussed it with him. Based on that discussion, I do believe the parties have reached an agreement. Understanding the nature of the case, at this time, I would ask for a plea and sentencing date to be set out on the calendar.
All right, Mr. Rapley, if that is your intent to accept the offer, it wouldn't involve a recommendation to the Court of Probation. If the court does not place you on probation and it is a court costs only matter, you would need to prepay $443 for the fines and fees. Excuse me?
Your Honor, just for the court's knowledge, Mr. Rapley is already on supervision.
Oh, well, that's good to know too. So, Mr. Rapley, when will you be able to save up $443?
I should be starting working here soon. I'm filling out my I-9 form because I messed up on it. But I should be working here by Monday, so within a couple weeks.
So do you want this resolved sooner rather than later?
Yeah.
All right, and then I am going to have to tell you though that does need to be prepaid $443. If it is prepaid prior to this hearing date, you do not need to come here in person.
Okay.
Okay?
Yeah, it shouldn't take me nothing but a couple weeks to at least be able to make some type of payments towards it.
All right. Does August 27th sound too early?
Yeah, I think that'd probably be a little too early right now. What's the date? The 6th, the 5th? 3 weeks.
I can do September 10th at
Yeah,
2:30.
Yeah, that works a little better. Yeah.
Unfortunately, it is a Mr. Schmidt week, but that's what I have. Does that work for you?
Yes, Your Honor.
All right. September 10th at 2:30. All right. Thank you, Mr. Rapley.
All
We are
right.
adjourned.
All right.
Mr. Young. How's your mom doing?
All right, yes, but
Is she home or
yeah, but she's always searching for words, you know, she starts talking and stuff.
she's what?
Searching for words, feeling where things are and stuff, but she just can't. But we were taking her back up to emergency after she got out of the hospital. Doctor said, no, there's no use because all her tests coming back normal. It's just old age catching up to her.
Well, I'm sorry to hear that she's declining. We will go on the record in the matters 25 CF 174, 26 CF 49, State of Wisconsin versus Dennis Young. The state appears through Assistant District Attorney Jose Vila in person. Mr. Young appears in person with counsel Joe Feliski. We're set today in this matter for status conferences. Mr. Feliski, please update the court.
Thank you, Your Honor. I am pleased to report it seems the parties have reached an agreement for Mr. Young to plead to count 1 and count 3 of the complaint in 25 CF 174 for costs only, with the option, were he able to get his license reinstated, to have the OAR, the count 3, dismissed. So at this time, I've discussed this offer with Mr. Young. I've discussed kind of the course of the negotiations here with Mr. Young, and I believe that he is comfortable proceeding with this offer. What I would ask for the court to do is to have a plea and sentencing date set out some ways on the calendar, and I'll explain why. In discussing this case, specifically the matter of getting his license reinstated, the last time I had spoken to Mr. Young, was my understanding he'd contacted the department and essentially had several $1,000s in fees to pay for that reinstatement. In discussing it with him, I've gotten some better clarity, I should say, on the situation, and it seems that what he is required to do is to have his payment plan first set up and then to begin making payments on that. He's anticipating having the first payment within 8 to 10 days, within about 8 to 10 days of today's date. Once that happens, it's my understanding, from his understanding, that the state would lift the administrative hold, so to speak, on him having his license reinstated. So the parties have reached an agreement. I'm just asking to have this set out.
Most people think missing court is no big deal until a judge proves otherwise. In this courtroom, Roger Peterson never shows up for his scheduled hearing. The judge checks the time, confirms that nearly 10 minutes have passed, and even notes that the courthouse security cameras show no sign of him entering the building. From the court's perspective, there is simply no excuse for the absence. The prosecutor asks the court to issue a warrant, and the judge agrees. But she doesn't stop there. Instead of a $500 cash warrant, she raises it to $1,000 cash, making it clear that failing to appear has serious consequences. Then comes another costly mistake. Because Peterson failed to appear, the judge finds him in default on 2 traffic-related cases. One results in a $200.50 assessment and 3 points on his driver's license, while the second adds another $263.50 in penalties. Both amounts must be paid within 30 days, and he won't receive a new court date until the cash bond is posted. It's a powerful reminder that ignoring a court date rarely makes a case disappear. In fact, it often makes the situation much worse, leading to larger financial penalties, warrants, and additional legal trouble that could have been avoided by simply showing